Hello, thanks for staying with us on BERNAMA today. Stay with me, Elaine Upline, and in the studio I'm speaking to Geeta Kandya. She is the IP expert or intellectual property expert, as well as the director of CAS International. And today we're talking about how you can protect your ideas when pitching to or meeting potential partners and investors, because we all fall into this category, Geeta. It's great that you're back to talk about intellectual property. We had all those series in the past, and now we have a new series of 5 segments that we'll hopefully be able to educate people to protect themselves. So let's start with ideas. You know, ideas are constantly brought up in discussions, right? Even when we're talking to friends, even talking to people. But how do we protect this from being stolen?
Good question, Elaine, and thanks for having me back as well. Ideas are constantly being brought up, and you need to sometimes share these ideas to get investors to invest into the idea, invest into the business.
Exactly.
Expand.
Yeah.
So the main thing to remember is ideas cannot be protected. The things in your head, the abstract, I know, it's sad, but the abstract ideas that you have, the thoughts that you have, that new business concept, the new product you want to place in the marketplace, whatever you have invented or innovations, the idea itself cannot be protected.
Okay, so which means people out there, the idea itself cannot be protected. So if you freely gave this information to someone else, they can use it.
That's right.
Okay.
So what needs to be looked at in detail is, can you reduce that idea into substance?
What is substance? What is the substance that we're looking at?
Okay, so let's give examples, then it'll be easier. We're talking about substance. Okay, what is substance? So you have an idea, for example, durians. Durians are very difficult to open. But you figured out and came up with a device that can open a durian easily and without injuring yourself. That when you speak about the idea, you speak how the mechanism works and all. That's just an idea. There's no actual product. Does it work? Does it not work? Is it going to be cheap to manufacture it? So the concept is there, the idea, but you haven't actually executed it.
Right.
So reducing its substance means develop the prototype, come up with a product.
Right.
Or if it's an idea, a special concept restaurant with a special name, come up with a name.
Right.
So it's reducing its substance, is coming up with something tangible that someone can actually see.
Right.
That's what reducing to substance means.
Right.
But sometimes ideas can't be reduced to substance and you need to share it.
Yes.
For example, back to the durian opener, you need a manufacturer to find out what's the cost of manufacturing, whether your device can be manufactured. So you might want to share it with a manufacturer. So that's when sometimes you still feel, I need to share it before I can reduce it to substance.
Yeah.
That's when it comes to, okay, how do you go about in those kinds of circumstances? Or even to manufacture your first prototype, you need an investor.
Yes, correct.
So when you need third parties and you can't reduce it to substance, then you're looking at, how do I protect this? So you have to break down your idea and see what elements can be protected through intellectual property law.
Yeah.
So you're looking at patents for inventions or innovations, trademarks for brands, copyright for any literary or artistic work, designs, if there's a design involved, the exterior part can be protected by design rights. If it can be protected, try to protect it. If it can't be protected, that's when it gets really tricky. You're looking at 3 things. You're looking at sharing what you need to share.
Right.
So try to limit what you need to share to get an investor interested.
Right.
Second thing is be careful with who you're sharing with.
Right. If you see this person is, regularly using or has a reputation, may not be the best person to do so with.
So, and some investors are reputable and are not going to then run off with the idea.
Right.
And third one is getting them to sign an NDA, which is a non-disclosure agreement.
Okay. But does that really protect in totality, just getting someone to sign an NDA?
So that's why it gets really tricky.
It may give you a false sense of security.
Security, yeah. Right. So an NDA, it's an agreement. So it's going to be both parties being obliged to keep the information regarding the new idea secretive, keeping it confidential.
Right.
That's what it is. It's an obligation. So if there is a breach of that obligation, breach of that NDA, what can you do? So the person with the idea will then need to sue the other person who has breached the confidence in court.
Right.
Will you actually enforce that in court? Will you go to court? So that's one thing.
Right.
You need to enforce that agreement.
Right.
Second thing is, see, if I enter into an NDA with you and I share with you an idea and you signed the NDA and you leaked it, I can sue you because that agreement's with you. But if a third party then takes that information that's revealed to public and utilizes that information, I am unable to sue them.
Oh dear.
Because my agreement's only with you.
Right.
So the bigger problem is that the NDA protects the relationship, the obligation between two people, two parties, but it doesn't protect the information being used, which is already leaked, being used by an unrelated party.
So that puts you in a quandary, isn't it?
So the NDA is limited. I think at most it deters people from trying to steal ideas.
Right.
But it's important that people know that NDAs are pretty much a deterrent, and you get some sort of satisfaction that at least the person that's signing the NDA can't reveal the information.
Right. Okay. So to first level, there's a single level that you'll be able to protect that information that you have shared with the person that you've chosen to share it with.
That's right.
Now, the difficulty would be, like you were saying, that how much do you share? You know, what are the points that you do share when you're trying to protect your idea? Because you need to share to a point where that investor or that third party gets it and understands it and wants to be part of this whole process.
That's right. So that's, again, it's a very grey area. So with innovation, sometimes it's easier because there's this thing called enabling disclosure. So if you have, okay, I'm going to give the example of the Dyson, you know, that bladeless fan?
Right. Yeah.
Right. So how does it work? So
no
I
idea.
can talk about the invention to an investor and say that this is going to revolutionize the industry because it's so safe. No kids, no one will put your hands in. It's cheaper to manufacture because there's no blades. So, but the person that he's sharing with wouldn't know the mechanisms behind
How
it.
does this work? But they get the idea of what product is going to be produced.
And it's new, it's novel in the market. It will actually be take off. It might take off because of the various concepts, business plans behind it. So there are elements that you can share. But you don't have to share every part of how the product works.
Okay.
If it's invention. So with products sometimes it's easier. Sharing the function of it. What is it going to do?
Because there's a physical item that you can sort of are clear in terms of what you can share because the mechanics of it is not shared, but the idea of how it works can be shared so that the investor gets on board.
So it's not an enabling disclosure. The person who's you've shared it with can't then go and manufacture that product.
Unless they figure it out themselves.
So that's the risk, because if you're giving too much information and they can figure it out themselves, then you, even later on when you want to seek protection, you might not be able to get patent protection because there's disclosure. So it's sharing information. The disclosure on confidential basis is fine, but disclosure, if it's not on confidential basis, will then even not allow you to get a patent protection for the invention.
It puts me, you know, I'm thinking about this, you know, sort of like, you know, all this information that you just shared with me. It's just very difficult to find that fine line of where do you, to what extent that you share and to what extent that you withhold. Because if your idea is, I wouldn't say not mature enough, but if your idea is quite rudimentary and someone else is able to improve on it and find a way to, you know, from this base idea, but not copy per se, they will be able to use whatever that you have started with.
Yeah, that's right. They say the best inventions in the world are ideas or innovations from other people's ideas, right?
Correct.
So Facebook was from Friendster, MySpace, then we had YouTube. So it is that as well. So sometimes they always say that the successful business is not sometimes the person with the idea, it's the person who executes it. So that's a whole other discussion by itself. So having the idea is one thing. Trying to protect it as much as possible with intellectual property rights is key. Where you can't, you then rely on NDA, but you know the risk of an NDA. So knowing the risk of the NDA, then you will then take precautions of who you will share it with. What am I going to share? What limits of my information do I need to share to get the person interested in investing?
Okay, so I mean, we've spoken quite extensively here, but how would you reduce this, whatever we've been speaking in this session, down to in terms of if someone were to go out and they have an idea, they want to pitch it to a potential partner, potential investor, third parties who could potentially take it themselves, what are the key points to keep in mind?
Key points would be break down whatever they're sharing to elements of what is it I'm sharing, are there any intellectual property rights? Get some preliminary advice. Can you get it protected? If you're getting protected, how much? Maybe get basic funds just to have it protected. That's the first level of protection if you can have it protected. Then the second one is depending on which party, because sometimes if you're entering into a relationship with the government, you're pitching to the government, they might not sign an NDA.
Exactly.
But if they are willing to sign an NDA, then NDA is the second level of protection. And then the third level of protection is always limit how much you need to share.
Okay.
So that would be tips.
So that sounds great. So you've got, from the horse's mouth in terms of, how best to protect your ideas. If you need more ideas, information, get a consultant. They will take you through perhaps in the steps that will be able to best keep your ideas protected.
That's right.
Thank you, Geeta. That's
Thank
all the
you,
time
Lynn.
that we have on this segment. Thanks for staying with us. We'll have more stories to share with you later. Stay tuned. Bye. Thank you.